So, welcome to our rural business briefing. It's great to see so many people signed up and attending this afternoon for what we hope will be an interesting and informative session with some of our specialists here at Brodie's. We ran these events as in-person events across Scotland over the last couple of months, and they were well attended and seemed to be well received. So we thought that we would do an online um, session to offer the content to those that couldn't attend those those sessions in person. We're joined this afternoon by colleagues from our tax and succession team, Emily Pike, Clive Phillips, who is a partner and head of our rural business and natural capital team, Sarah Lilly, a partner in our family team, and also Scott Logan, a partner in our real estate team who specialises in infrastructure and utilities. Emily's going to kick us off this afternoon discussing tax and succession, which with the upcoming budget will clearly be at the forefront of a lot of people's minds. She'll then be followed by Clive on partnership structures. Then Sarah will provide a session on family law, followed finally by Scott covering utilities. So without further ado, Emily, over to you.
Thanks, Alex, and good afternoon, everyone. So, as Alex said, the upcoming November 2025 budget is at the forefront of a lot of people's minds, but we here are also thinking a lot about last year's budget in the autumn of 2024, which, as a lot of you will know, introduced enormous far-reaching changes to inheritance tax. Next slide, please. So those proposals have now been consulted on. Draft legislation is out. I don't propose in this session to go into the changes in an enormous amount of detail, but I did just want to summarise it for you all. Next slide, please. So the focus of the changes that I wanted to talk about, as you might expect, is the changes that will be made from the 6th of April 2026, coming up very quickly, to agricultural property relief, known as APR, and business property relief, known as BPR. So, as a reminder, these are extremely valuable reliefs from inheritance tax to anyone who has qualifying assets. Inheritance tax otherwise is charged at 40% on death, and it's also suffered by trusts in most cases. What APR and BPR allow for at the moment until April is up to the full value of those assets to pass on inheritance tax free. But there are strict requirements to qualify for those reliefs, and none of that is changing. So some of the nuances around which assets will qualify for full relief and partial relief, what the ownership periods are, for example, for those reliefs, and the fact that APR only applies to the agricultural value of assets, not full market value, which might be different. None of that's changing as far as we know at the present time. So these are all really important points to be aware of, and they remain important going forward. Next slide, please. So from the 6th of April, the first £1 million of those qualifying assets will still be, if they are currently, they will still be from that date free of inheritance tax due to APR or BPR. But the balance of assets will only benefit from half of that relief. So that means an effective rate of 20% for individuals. And it will also apply to the inheritance tax charges in trust. What we did learn in a bit more detail when the draft legislation came out was that lifetime gifts will also be impacted by those changes if the person making those gifts dies on or after that date in April 2026. But we did also learn that there is a proposal, at least at the current time, for those allowances of £1 million to refresh every 7 years. So in theory, there could be a sort of ongoing programme of making use of those allowances, and I'll touch on that in a minute. But really importantly, this £1 million allowance is, as we see it right now, not going to be transferable between spouses or civil partners. So what that means is that unlike the nil rate band, of 325,000, which is transferable. So on the death of the second of a couple, it can be used if it hasn't been used already. That won't be the case with this £1 million allowance. It is an individual allowance, and it's a use it or a lose it situation, again, which I'll come back to. Next slide, please. So for now, the basics of inheritance tax and the lifetime giving proposals are staying the same. There is a budget coming up in not very long, as some of us here are all too aware. But unless that budget changes anything drastically in terms of lifetime gifting rules, for example, the usual rules that apply in relation to inheritance tax, some of which I've put on the screen there, will carry on applying as they do now. They will interact in an interesting way, sometimes a challenging way with the new rules on APR and BPR, but essentially they will remain the same. Next slide, please. I've tried to set out some of the implications, the most obvious being higher tax bills on death, and also for trusts, of course. But I've also set out some examples of how this might impact in a very simplistic example on farms of different values. So for £1 million farm, if you've got the full allowance, there should be no impact on the inheritance tax position. Going right up to a £10 million farm, where there'll be a substantial amount of additional tax to pay. So it's a real issue. Next slide, please. So I just wanted to look now at and really focus for the rest of the time I have on what planning might be undertaken. So both before 6th of April 2026 and what we might see after that date when the new rules are fully in force. I'll focus really on a few key areas. So first of all, on planning for spouses or civil partners. Second of all, for the lifetime giving options that might be available and how that interacts with trusts. Thirdly, on the use of partnerships. And then a couple of final points just to note around leases and insurance. Next slide, please. So for spouses and civil partners, the most important takeaway, I think, from certainly this part of today's session will be that wills must be up to date and must be as inheritance tax efficient as possible to avoid losing that £1 million allowance between spouses and civil partners. So it really, as I said, is a use it or lose it situation. There are ways of ensuring, as long as each spouse or civil partner has assets up to that £1 million threshold in their names that they can pass on by will, there are ways of ensuring that these allowances are captured. I've set out some suggestions on the slide there. So a trust, for example, for the spouse and the family to take advantage of that allowance, and also maybe leaving assets outright to children, if appropriate, might be another option. But I think just making sure that any asset protection issues around those choices are considered is really important as well. Next slide, please. Looking at accelerating lifetime giving, this is probably the main focus of a lot of the planning that many of us are involved in at the moment. And that's because there are specific opportunities for that sort of planning before April. So dividing it into two categories, outright gifting before April, as long as somebody survives 7 years, then the value will fall outside their estate for inheritance tax purposes. If they die before April, this coming April, it will still be under the old regime. So even if it comes back into their estate, the new rules aren't in yet. And so we're still under the old regime. If they die after that date, the new rules will come in. The failed gift is subject to that £1 million allowance. But you've sort of frozen the value of that asset, if you like, as at the date of the gift. So there are still advantages of doing it that way. For gifts into trust, this is another area where we're seeing quite a lot of activity. The use of trusts can be really helpful because it allows for that control to be maintained by the person making the gift. It also allows asset protection to be built in. So in comparison to outright gift giving, where the asset by its nature will be passing to someone to use freely, and may therefore be subject to threats of divorce, financial difficulty, etc., in their hands, the use of trusts can be very helpful on that front. And I know Sarah will also look at some of the pre and postnuptial agreement arrangements on that topic as well. And there are, of course, partnership agreements and shareholders agreements that can be relevant. But I think what's really important to note on gifts into trust before April is that because we're still operating under this old, if you like, regime, the new rules on inheritance tax from 6th of April won't yet apply to that transfer. And so it should be possible to move qualifying assets into a trust free of inheritance tax, which it won't be after that date. And that's up to any level, not subject to £1 million allowance. Next slide, please. So I've talked about the fact that trust planning is likely to remain a viable option after 6th of April. And I think it's really important to note that there is still scope after 6th of April to make use of trusts without upfront IHT costs. And by adding on available nil rate bands, and potentially looking at the fact that you can make fresh gifts using up the £1 million allowance every 7 years, you could potentially get quite a lot of value into trust over time. So I think we'll start to see more and more of a programme of gifting into trust if the circumstances are right for the family. Important to note, of course, that the trust, if it's the type of trust that suffers 10-year charges, which most are these days, if it's over £1 million in value, then it will suffer IHT on relievable APR or BPR assets. And because of the way that I won't go into now, but because of the way that the allowance is split between different trusts, it may have actually less than £1 million to play with on that front. So always important to have a think about that. And also to look at how complex trusts are, because they can be, and they can also obviously have costs of administration associated with them. Next slide, please. Just in the last couple of minutes, I just wanted to look at partnerships, leases and life insurance, because I think these are also areas where we'll start to see much more activity because of the implications of the changes to the IHT rules. Partnerships, of course, are a long-standing feature of family farming businesses, but also more widely, rural businesses and others in general have often been using partnerships as a way of managing those assets. It is a bit of a staging post, if you like, between outright ownership and retention by one individual and gifting outright to family members. Clive will talk us through some of the key points around partnerships and partnership agreements in particular shortly. But in the context of giving, they are often a very useful tool for bringing the next generation into the business, maybe initially with no interest in capital, but gradually over time, that developing. And I think if the new rules, as we'll see them from 6th of April, are going to start encouraging lifetime giving, then we're likely to see partnerships being used by families as an increasingly popular way of bringing in the next generation. So making use of maybe their £1 million allowances individually, but also bringing them into the management of a business and allowing that to operate successfully. Next slide, please. This is a complex area, the use of leases, and so it's just really important to note that it's not straightforward. However, it is being argued at the moment that using leases, so leasing out land that is, say, within a farming partnership under certain terms, may suppress the value of that asset and therefore may have an impact, positive impact, you could say, on the inheritance tax charge. So it's not, don't have time to go into the detail of that today, but it's important, I suppose, to think about any implications that that might have and whether it could be something that's worth exploring. And then finally, if you move on to the next slide, I just wanted to look at the use of life assurance, which I think we are increasingly seeing come into play even more now that it looks like there will be larger inheritance tax charges on these sorts of assets. I am not giving financial advice. I'm not qualified to give financial advice. It's important, however, to consider insurance in inheritance tax mitigation. And we work closely with inheritance tax assurance specialists who will be able to provide that sort of advice. I've just divided up the type of policy there into three. So the sort of 7-year risk policy, which is for a specific purpose. Also the term assurance policy, which is maybe someone who wants to make gifts but hasn't just yet. And then also whole of life cover, which is likely to be the most expensive option, but would cover obviously on the death occurring. So these are important points to think about. Always take advice on life insurance, I would say, because of the traps that you can fall into with it. It's really important to make sure that it works in conjunction with the rest of the estate plan. Next slide, please. So this is my final option, weather the storm. There is a storm coming, undoubtedly. For a lot of us, it feels like perhaps it's already here. Some take the view that this will be a passing storm with inheritance tax, and perhaps future changes, maybe in not very long, maybe in a very long time, will make a difference to it. But I think we would probably recommend that planning for the worst is certainly the more prudent option, because you never know what life will bring. And we would certainly all prepare to be surprised after what we've seen over the last 18 months or so. That's all from me. So I think I'll hand over to Clive for our next session.
Thank you. Thank you very much, Emily. Yeah, I'm going to talk about partnerships. And as Emily said, they have long been they've long been a feature of the agricultural sector, particularly, but the rural sector more generally. And as Emily said as well, they are a kind of staging post, if you like, between outright ownership and gifting, and it starts to involve other people, other generations, and at the same time retains a degree of kind of management control and direction. So there's lots of good commercial reasons for them, and there are good succession planning reasons for them. And there is no doubt about it that the proposed changes in inheritance tax are going to encourage people to move assets down the generations. And so I think we will see a lot more activity around partnerships in terms of bringing the next generation in. So Ewan, if you could flip slide, please. Yeah. So I'm going to just look at a few of the key issues around partnerships just very briefly because time is quite short. Going to have a look at constituting partnerships, relationships between the partners, the termination events and valuations at those key points. Have a bit of a look at land and legal rights. And then lastly, just talk a little bit about leases to partnerships because there are a few peculiarities there. So go to the next one. Yeah. So talking about constitution, great thing about partnerships, they're very informal, very flexible. The bad thing about partnerships is they are very informal and very flexible. And by that, I mean that partnerships are regulated by the Partnership Act of 1890, but there is a very high degree of freedom of contract in terms of what the partners actually agree. And the Partnership Act just provides a kind of default backdrop if it's not clear what the partners have agreed. Unlike limited companies, there's no registration process, there's no requirement even to have a partnership agreement. So you have to look at the evidence of how the partners interact with each other very often to find out what the terms of the partnership agreement are. And that's really what I mean in terms of the great thing is the flexibility, but the downside is also the flexibility and the fact that you have to look at all the evidence to find out what the parties have agreed. So, in theory, it is possible for the parties to agree a variation over the breakfast table, and as long as that can be evidenced, that is then binding on the partners. So, best advice always is to put a written partnership agreement in place. So, if we go to the next slide, so if we turn now to the relationship between the partners, critical to all partnerships, which are fundamentally set up with a view to a profit. We need to understand how profit shares are going to operate. And there is a distinction between revenue profits and losses and capital profits and losses. And if you don't say anything specific about capital profits and losses, they will be shared in the same proportion as revenue profits and losses. And that can come as a bit of a surprise to people because sometimes you get a partnership where one partner will have a big capital account, the other partner has a very small capital account, and they will assume that capital profits, if they sell an asset or they revalue an asset, will follow those capital accounts. But that's not really the case. They will be shared in accordance with the revenue profit sharing ratios unless there is specific provision around capital. And I think the reason for that is that when the partnership legislation was enacted, it was really dealing with trading partnerships. So you might argue that the capital in the partnership is just reflecting the trading activity, and therefore why shouldn't it follow revenue profits? The problems with farming partnerships and estates is that they're land-based, and very often the capital, the increase in capital is driven by land values and not the trading activities of the partners. So the best advice there is to at least be aware of that difference, be aware of the default position, and if you don't want the default position, you want to say something specific about it. Good thing about flexibility is that you can have different types of profit share structure for new partners. So you can bring a new partner in with a very low profit share and increase that over time. Or you might say that the first proportion of profits will go to that partner if they're the partner that's doing the heavy lifting on a day-to-day basis, and then the rest of the profit shared in a different proportion. So there's a bit of flexibility there. Very often, particularly in farming partnerships, you will see that one or more members of the partnership have introduced the capital, the heritable property, i.e. the farms or the estate or the forestry, into the partnership business. And it is possible to ring fence that as heritable property accounts and to then deal with them and any capital profits in a different way from other capital. So you could say, for example, in the heritable property capital accounts, 90% of the profits go to partner A and the other 5% go to B and C. But then you might say any other capital profits are shared equally, and you might say revenue profits do something different again. You always have to think about carefully about whether land should be in or out of the partnership, and there's quite a lot to think about there, which I'm not going to go into in a great lot of detail. There are some tax considerations, and of course, if you are wanting to use the partnership to move value around, you want to have the land in, but there are implications of that. If you don't want the land in, you need to be careful and not bring it into the partnership by accident. So even if you've got the title to the land sitting in the names of the individual partners, just ostensibly in their own name, if you start to introduce that onto the balance sheet of the accounts of the partnership, then arguably it becomes a partnership asset. And that is not, if that's not what's intended, then you want to guard against that. You need to give some thought to decision making. It's possible to have all sorts of decision making arrangements in a partnership. Most rural partnerships tend to be pretty basic on this point, but we could be a lot more imaginative. You can create weighted voting. You can effectively allocate almost shares, if you like, so that people have different voting power for different types of decision. And as we'll hear, we've heard from Emily on life insurance. We'll hear from Sarah on prenup in relation to matrimonial. There's no reason that the partnership agreement cannot say that if a partner is to get married, they should put a prenup in place, or that you should have life insurance in place. Because at the end of the day, these partnerships are often multi-generational. There are a number of generations and families and individuals who are relying on the partnership, not only for their income, but very often for their home as well. So these kind of protections are there to protect the rest of the family as well. You could flip that on. Yeah, so just talking about land. So the issue with land really is that it can really boost the impact of valuation events. So if you get to a point where you have to revalue the partnership, and we'll touch on that in a minute, the revaluation of land can have a significant impact on that. That's why it's really important to understand how capital profits are going to be shared. I've talked about ring fencing heritable properties, so having a property account that's shared in a different way. And I've talked about checking if the land is a partnership asset or not. Once land is a partnership asset, then it effectively becomes movable for the purposes of succession. And the reason is that the individual partners do not own the underlying land. They effectively own a pizza slice in the value of the partnership. So if the partnership is worth £2 million and you own half of it, you don't own the land, you don't own the tractors, the stock, all of that, but you own the value of that pizza slice. So what that means is that in succession, it's treated as movable for the purposes of calculating legal rights. And legal rights are a claim that spouses and children have against a parent's or spouse's estate. Now, there is an opportunity under the Partnership Act to enter into what's called a Section 22 declaration, which effectively says, even although my pizza slice is movable, we are still going to treat it as if it was still land for succession. Now, there are some views that Section 22 declaration might potentially be open to challenge by third parties. But, the Act's been around since 1890. It's not been challenged yet. There are a number of hurdles to challenging it. So whilst you might not want to rely on it in a particularly hostile legal rights situation, it's certainly a piece of protection that you can put in place as part of your management of that risk, particularly if you are bringing the other parties that are going to be potential legal rights claimants into the partnership as well, and they're all signing up to it. The next slide, please. Hello, Ewan, next slide. Right, okay. Yeah, so, oh gosh, I think we've maybe flipped two, have we, Ewan? Sorry. Yes, maybe that's my fault. Apologies. So just going to talk about termination and valuation. And the termination events or valuation events, strictly speaking, occur whenever there is a change of partners, whether by resignation, or death or expulsion. And those events usually require a revaluation of the partnership in order to determine what the value of that outgoing partner's pizza slice is. And what partnership agreements usually provide is that in that event, the continuing partners, the remaining partners, will have the option to acquire the outgoing partner's share. And the outgoing partner's interest is a cash right. It's not assets. They're not entitled to take the farmhouse away, the land away, the stock away, the tractors away, and nor are they entitled to bequeath a seat at the partnership table. So they cannot say in their will, in the event of my death, my son or daughter will become a partner of the partnership. They can give away the value of their pizza slice, but not the seat. Now, in practice, of course, there may then be a discussion between the ongoing continuing partners and the beneficiary of that value of that share in the partnership as to whether they might join the partnership, or in fact, they may already be a partner and they will just move their capital from one capital account to another. There are some timetables to be aware of, contractual timetables where the partnership agreement may say that if the continuing partners wish to exercise the option to acquire the outgoing partner's share, they must do that within a specific timescale, and they should watch and observe that. There are different approaches to valuation, and essentially the two opposite ends of the spectrum. One is to take the balance sheet values, which are historical values, and the other is to do a full revaluation. The historical values will protect the partnership, but they don't really give the outgoing partner or his or her estate a fair share of any increase in value, because the balance sheet is likely to be historical. A revaluation will obviously boost the values and can make it a very significant liability for the ongoing partnership to pay out. And very often that will be paid out over a number of years. And I've mentioned before capital profits and revenue profits. Ewan, you could flip to the next one, please. Yes, so partnerships, as I've said, they do provide a lot of opportunity to bring in the next generation, to bring them in as a partner with a small share of capital, perhaps a small share of profits, and then over time you can increase their capital share, subject to tax, of course. There's gifting rules, the CGT, all that kind of stuff. But there is the opportunity to do that relatively easily, generally just by adjusting the accounts of the partnership and ideally documenting that as an addendum to the partnership. There's also then the opportunity to fragment the value of the capital assets, particularly land. So this is touching on Emily's point that we've got these £1 million reliefs. So, we want to maximize that. The more people sitting around the table sharing the value of the family silver, if you like, in terms of the farms, the more reliefs that you're potentially going to have available. And as Emily said as well, there's this kind of halfway house that you can layer up decision making so that some decisions are reserved to particular partners, different profit and salary structures, and the progressive transfer of value as trust in the next generation grows. And you can also have termination provisions, which will have very long payout periods, so that, again, it discourages a new partner from coming in, taking their value and running. So all of those things can be put in there to try and manage that whole succession piece. I mentioned here, beware of the risks of GROB, which is a gift with reservation of benefit. And if GROB applies, then effectively it's as if the gift or the transfer of value has not taken place. So if you were to bring a new partner in and give them capital and all of that, but you retain so much control as one of the other partners, then you may run the risk of bringing it into the gift for reservation of benefit net. Just one other thing I'd mention in relation to flexibility on succession is most farming partnerships, most rural partnerships tend to be intra-family, so they're all family members. But many commercial partnerships, such as a legal partnership, they are partnerships between unconnected parties. And increasingly, we're seeing a lot more sort of joint venture arrangements. And these can often be done very well through a partnership, where they are bringing in third parties into the partnership, both bringing different skills, different capital contributions, and sharing profits in different ways. But they can offer some really helpful solutions and helpful alternatives to traditional agricultural tenancy type arrangements. Go to the next slide. So just to wrap up very quickly, just talk very briefly about leases in the name of a partnership. It's well established that individual tenants can farm through the vehicle of a partnership. Where we have more problems potentially is when you have a lease to a partnership, because unless there is something specific written into the lease, then most leases will not survive a change of partnership. That's because effectively, when you get a change of partners through assumption of a new partner or death or retirement of an existing partner, you're changing the nature of that partnership entity, and the lease will not survive but will fall. And that's the case really, even if the partnership agreement itself says that the partnership will continue even in the event of a change of partners. And that's because the landlord is not a party to that partnership agreement. So you always have to, if you're in that situation, there are specific provisions that can be put in leases to cover that off. And some leases will be specifically to what's called the house of the partnership, i.e. an ongoing partnership. But if you have a lease to a partnership, you need to check the lease terms. And if there is an issue around that, you need to think about managing that position with the landlord and ideally recording that in the lease. Next slide. Yeah, so that's me finished on partnerships. We're happy to take questions. I'll now hand over to, I think it's Sarah Lilly's going to talk about matrimonial issues. Sarah.
Thanks very much, Clive. Yes, so in the agricultural world, family farms represent not only a source of income, but also a cherished legacy passed down through generations. The complexity of managing these assets can become even more intricate when marriage, separation or cohabitation are involved. So an understanding of prenuptial, postnuptial and cohabitation agreements is crucial for the farming communities of Scotland. They are legal instruments that provide a framework for protecting the interests of all parties involved and preserving the integrity and sustainability of the farm. So I'm going to address you in two separate parts, one relating to marriage and the other quite distinct issue relating to cohabitation. They are very different in terms of their legal positions. So can I have the next slide, please? So in order to understand the importance of a prenuptial agreement, it's important to understand firstly how Scots law deals with the division of matrimonial property when no such agreement exists. The Family Law Scotland Act 1985 sets out the principles to be applied when dealing with financial provision on divorce. Now, the emphasis of that act is on the parties achieving a clean break with the aim of them each returning to financial independence as soon as possible. Matrimonial property is all property belonging to parties, jointly or separately, which is accumulated during the marriage and which still exists as at the date of separation. Now, there is a specific exemption in legislation where the property is acquired by one person via a gift or inheritance from a third party, and this relates exactly to what Emily and Clive have just spoken about in relation to gifts. Providing that gift or inheritance stays in the same form or in substantially the same form, that property falls out with the scope of matrimonial property for the purposes of division at the point of separation. However, if the funds gifted or inherited are used to purchase a different form of property during the marriage, the property can be converted into matrimonial property, and another name for that is matrimonialised, and falls subject to the rules of division, which I'm going to set out. The starting point for financial division in any case of matrimonial breakdown is to consider the principle of the fair sharing of matrimonial property. To establish this, we ascertain from our clients what matrimonial property existed as at the date of separation and the value of that property. And when I talk about property, I'm talking about assets and liabilities. Once we have those valuations and evidence of them, we can then begin the process of advising how that property is to be divided fairly, and the starting point in law is equally. Having said all of that, as a family lawyer, there are certain distinctive issues that I'm aware of in relation to the breakdown of marriage within a farming family. This is particularly the case where farms and crofts are involved, as they often vary from other assets in relation to the sometimes complex ownership and business structures that exist around them. Crofts and farms can either be tenanted or owned. It is not unusual for the owner or the tenant of a croft or farm to be different to the person or entity that actually farms the holding. The farming business often operates on multiple holdings, and the ownership or tenancy structure across these holdings can vary and may have been acquired at different times and in different ways. So when negotiating the division of property on separation where farming or crofting interests are involved, it's essential to build a full picture of the ownership or tenancy position, the timings of each acquisition, and visibility of the business structure, including sight of any partnership agreement or shareholder agreement, and the farming business accounts. It will almost always be necessary to have the farm or croft valued by a specialist surveyor and the business valued by a specialist accountant. Another common issue in farming families is when a farm has been inherited. Commonly, farms and crofts either owned or tenanted, and farming businesses are passed down through generations. And if this is the case, whether or not a party to the marriage inherits a croft or farm before or during the marriage, it is not matrimonial property. But there are two issues to consider in these circumstances. One is that which I've already mentioned, being the ability to knowingly or inadvertently convert the inherited asset into matrimonial property. The other is that the value of that inherited agricultural asset can be taken into account when considering the respective resources of the spouses and deciding how the matrimonial property is to be divided. Move the slides, please. So why have a prenuptial agreement? Well, the prenuptial agreement is a legally binding contract entered into by a couple for marriage. It outlines the distribution of assets, financial responsibilities, and provisions for property division in the event of a separation or divorce. The parties to the prenup can be as creative as they wish in relation to what is provided for in the agreement. In an ideal situation, both parties will obtain independent financial advice during the drafting process, with a draft passing between solicitors until both are content with the terms of it. It is not possible, no matter how much parties are in agreement, for one lawyer to act for both of them in relation to the drafting of a prenup. And then the agreement is signed. In Scotland, properly prepared and signed prenuptial agreements are valid, legally binding documents that will be upheld if challenged in court. The refusal by one party to take legal advice does weaken the strength of the agreement, but that point has not ever actually been litigated within the courts in Scotland. Over the course of my nearly 18-year career as a family law solicitor, I've drafted a number of prenuptial agreements on behalf of clients. However, it's undoubtedly the case that I have seen an increase in their popularity over recent years. Despite this, they are still comparatively rare, and the absence of them can result in lengthy and often costly negotiations or even litigation in relation to how the matrimonial property is to be divided. For the farming community, prenuptial agreements can play an essential role in safeguarding the farm from being divided or sold during a potential divorce. Farming families often span multiple generations and involve substantial inherited assets. The proper drafting of a prenuptial agreement can ensure that the farm remains within the family and continues to operate without disruption. Now, a postnuptial agreement is similar to a prenuptial agreement, but is entered into after the marriage has taken place. It serves as a tool to adjust changes in the circumstances and provide clarity on financial arrangements and asset division in exactly the same way as a prenuptial agreement does. I have had experience of people approaching me in such close proximity to the wedding, in fact, days before, looking for a prenuptial agreement to be drafted, that it's not been possible to do that, and instead we've simply entered into a postnuptial agreement within the weeks that follow the wedding. The other circumstance which can trigger the need for a postnuptial agreement is when a person acquires new assets or inheritances during the marriage. In the case of a farming relationship, the entering into, at that stage of a postnuptial agreement, can provide a clear plan for asset distribution, ensuring the farm remains operational and within the family in the event of any future separation. In the case of both prenuptial and postnuptial agreements, it's often helpful to keep the agreements under review as the years pass. There can be unexpected changes in the financial circumstances of one or both parties, which have not been adequately provided for in the agreement and which can then be addressed in the event of any future change. It's fair to say that as family lawyers, we can often be quite anxious about the drafting of pre- and post-nuptial agreements because to a large extent we are trying to predict the future and prepare for any eventuality. However, it's not always possible to do that, so the review by the couple regularly of the terms of that agreement is sensible. We advise them to do that. Next slide, please. Right, so I quite enjoy a statistic when it comes to relationship trends, and the most recent Scottish statistics came about as a consequence of the 2022 census, which provided the data you can see on screen. Since 2011, there has been a 25% rise in cohabiting couples. Since 2001, there has been an 80% rise in cohabiting couples. Between 2001 and 2022, the percentage of households with couples which were married has decreased from 86% to 76%. And you can see there on the slide the marriages in Scotland over the past 50 years, and numbers have significantly decreased. It's therefore clearly the case that the cohabiting couple is on the rise and the married couple is on the decrease. However, it is estimated that about 5.3% of cohabiting couples separate in the UK each year, compared with only 1.3% of married couples. So as family lawyers, we need to be alive to this and consider the legal implications for the end of cohabiting relationships. Prior to the Family Law Act, Scotland Act 2006, cohabiting couples in Scotland had no rights whatsoever in relation to property post-separation. However, the provisions of the 2006 Act differ significantly to the provisions of the Family Law Act 1985 in relation to the division of property. Cohabitants are defined in the 2006 Act as a couple, be they opposite sex or same sex, who live together as if they were husband and wife, and that is the phrase used in the legislation, as if they were husband and wife. Essentially, couples who live together in a committed relationship. So when a cohabitation ends and no cohabitation agreement exists, the starting point for cohabiting couples is the opposite of that to married couples. Neither has a right to share in the assets of the other built up during the relationship. There's no pot of assets to be divided, and instead each party simply keeps what they have. However, in certain circumstances, one partner can make a financial claim against the other. Such a claim can be made if a partner has derived an economic advantage from the contributions by the other, or if a party has suffered economic disadvantage in the interests of their partner or child. Unlike when a marriage ends, when no time limit exists for the making of a claim post-separation, in the case of a cohabitation ending, the claim must be made within 12 months from the date of separation. After that period expires, no claim can be made in any circumstances. Despite rights for cohabiting couples having existed in Scotland for 19 years, it is still an area of uncertainty, with the legislation being far less definitive than that relating to marriage. It's for that reason that a cohabitation agreement in some relationships, and particularly relationships involving significant wealth or businesses on the part of one or both parties, in respect of a cohabitation agreement, could arguably be even more important than that of a prenuptial agreement. It will not come as a surprise to anyone that a cohabitation agreement has a similar effect to prenup and postnup agreements. A couple can make a provision in a cohabitation agreement for what is to happen in the event of the relationship ending, and that therefore removes the uncertainties presented by the 2006 Act. So in conclusion, for the farming community of Scotland, prenuptial, postnuptial and cohabitation agreements are a vital insurance policy and a tool for protecting agricultural assets and ensuring the continuity of family farms. In short, they provide a mechanism by which couples can take control of the outcomes of a future separation by contracting out of the legislative provisions. By addressing potential issues proactively, these agreements provide peace of mind and create a stable foundation for both personal and professional aspects of life on the farm. Seeking legal advice and ensuring fair, transparent agreements can help preserve the legacy of family farms for future generations. And that's me, and I'll now pass on to my colleague Scott.
Thanks, Sarah. So moving on to utilities, and yeah, if we can go on to the next slide, Ewan. The various utility providers, be it electricity, gas, water, telecoms, have wide-ranging statutory powers enabling them to compulsorily acquire rights to place their equipment on land. The exercise of compulsory powers for these purposes is generally recognised as being in the public interest, given the need for utilities, but nonetheless, affected parties can feel that their rights are easily overlooked in the process and that compensation is inadequate. Compulsory powers can be found in a range of statutes applicable to the different regimes. Each has its own rules and procedures, and it is difficult to understand why some regimes are more favourable to affected parties than others, but that is undoubtedly the case. Now, given the multi-billion pound investment plan for the electricity networks in Scotland to meet the ambitious target set for renewable energy generation as part of our transition to net zero, I'm going to focus this afternoon on electricity and the powers available to licence holders under the Electricity Act 1989. These powers are wide-ranging, giving the electricity companies a number of options when it comes to acquiring rights and land. And if we could move on, please. So Schedule 3 of the Electricity Act gives powers to licence holders to compulsorily acquire land and also rights and land. Licence holders can use these compulsory purchase powers for any purpose connected with the carrying out of the activities for which they're licensed to carry on. So, for example, this power might be used to acquire land for the construction of a new electricity substation, or indeed for acquiring a servitude right of access to get to and from such a substation. Schedule 4 of the Electricity Act then gives licence holders other statutory powers, including the power to acquire necessary wayleaves, a term that I'm sure many of you will be familiar with. This statutory form of wayleave permits the installation and retention of electric lines and ancillary apparatus on land. And the key distinction between a necessary wayleave and a negotiated or voluntary wayleave is that a necessary wayleave runs with the land and binds successors in title for the period specified in the wayleave. In contrast, a voluntary wayleave will normally fall on change of ownership. In most cases, the electricity company will attempt to negotiate a voluntary acquisition in the first instance. And as those discussions will take place under the shadow of compulsory purchase, most negotiations end up with a deal being struck. Clearly, for landowners to be able to assess the strength or otherwise of their position, they need to understand the extent of the company's powers and the likelihood of compulsory purchase being sanctioned at the end of the day. If we could move on again. So for new infrastructure, a licence holder may formally request the grant of a wayleave from the owner or occupier of the land, allowing them to install and keep installed an electric line on, under, or over the land in question. If the owner or the occupier fails to give the necessary wayleave within the period specified in the notice, which is usually the minimum 21-day statutory period, then the licence holder may make an application to the Scottish Ministers for a necessary wayleave. Similarly, in relation to existing infrastructure where a previous wayleave has expired or has otherwise been terminated, licence holders have a period of 3 months following receipt of any notice to remove from the land to apply for a necessary wayleave or to make a CPO to keep the electric line in place, and provided they do that within that 3-month period, the line is then protected until the necessary wayleave application or the CPO is finally determined. Before granting a necessary wayleave, the Scottish Ministers will afford the owner and any occupier of the land the opportunity to be heard. This may take the form of a public inquiry or a less formal hearing in front of the appointed reporter on whose recommendation the Ministers then take a final decision. Wayleave hearings largely focus on site-specific matters, so a wayleave hearing is not an opportunity to challenge the need for the related scheme or the choice of overall route. Rather, the hearing should be concerned with issues relating to the land in question. The reporter will generally consider two issues. Firstly, is it necessary or expedient for the electric line to cross the land along the wayleave application route in order to meet a specific electricity supply need? And then secondly, what effect will the line have on the use and enjoyment of the land in question? And that second question gives rise to a balancing exercise between the public interest on one hand and private property interests on the other, ensuring that the process is human rights compliant. It must be recognised, however, that the odds are very much stacked against owners in this process, and that the prospects of successfully resisting an application are not generally high. It would generally be expected that the licence holder will be able to establish the first part of the test to the reporter's satisfaction, and thereafter it will take something fairly significant by way of adverse impact to swing matters back in favour of the owner, particularly given the availability of compensation. If we could have next slide, please. So where a wayleave or servitude is entered into voluntarily, any compensation or consideration due will be governed by the terms of that agreement. In the case of a necessary wayleave, the entitlement to compensation is governed by paragraph 7 of Schedule 4. Where a necessary wayleave is granted, the owner or occupier may recover from the licence holder compensation in respect of the grant. And compensation is also available for damage and disturbance arising from the exercise of the rights. Now, the phrase compensation in respect of the grant is not particularly helpful, but case law has indicated that the general compulsory purchase principle of financial equivalence will apply in these cases, and also that injurious affection may be claimed. And here the injurious affection may arise in two ways. Firstly, it may apply to the strip of land over which the rights have been granted, so your wayleave corridor or servitude corridor, but it may also apply to the wider landholding of which that strip forms part. Could we move on to the final slide, please? In cases where compulsory powers are used, landowners should consider carefully whether or not an objection should be made. It should be stressed that it is seldom the case that opposition will result in a CPO or an application for a necessary wayleave being refused, and certainly considerable expense will be incurred in maintaining an objection all the way through the process. There may, however, be very good tactical reasons for making an objection, whether that's to secure a fairly minor but important route alteration, mitigations, or other benefits, for example, accommodation works. In each case, it will depend upon the particular circumstances and a weighing up of the potential gains against the costs and risks involved. As for negotiating more favourable terms in any consensual agreement, and indeed most matters do proceed on a consensual basis, there are a number of areas in particular where adverse impacts can be minimised. Perhaps the most important here is agreeing the location of the apparatus and the extent of any wayleave corridor. It is important to clearly identify the agreed route on the relevant wayleave or servitude plan and ensure that within the documentation, the rights are limited so far as possible to that defined route. As the compensation will be based on this, provision should be made for additional compensation to be paid in the event that contractors cause damage out with agreed working areas, or in the event that the construction period is extended beyond that originally contemplated. The duration of any agreement should also be considered. The electricity companies will typically insist on a perpetual servitude if injurious affection compensation is being paid out, and in most cases, landowners may be willing to grant a servitude given the more or less permanent nature of the infrastructure and the statutory protection that it has. However, it is certainly not a case of one size fits all, and there may be very good reasons to opt for a wayleave that can be terminated on notice if, for example, a landowner wishes to preserve the ability to claim compensation for loss of development value in the future. And then finally, in relation to the consideration and compensation package, the starting point here will be the payments that a landowner can expect to receive if the rights are acquired compulsorily. However, it is often the case that higher payments can be secured through negotiation to avoid the additional time and costs involved if the electricity company has to proceed under its compulsory powers. And I'll just bring an end to my presentation here and pass back to Alex.
Thanks very much, Scott, for that. That is us bang on at 5 o'clock, or in fact 1 minute over 5 o'clock. So rather than keep you with question and answers, if you would like to have any questions answered, then please do feel free to contact our speakers directly, and they will do their best to answer your questions. I would also add that today's slides will be shared with everybody who signed up for today's session. Our rural business newsletter will be available shortly on our website and also to our mailing list, so please do look at that. And if you would like to see us in person, we will be attending AgriScot next week, and we're also hosting Scottish Land and Estates London reception at the beginning of December, which some of you may be attending. So I think it just remains for me to thank our speakers for their informative and interesting talks. So that's Emily, Clive, Sarah and Scott, and thank all of you for attending today. I hope you found it useful and enjoy the rest of your evening. Thank you.